Hey guys, welcome back to Courtroom Clapbacks. This is Vicki, and today we are headed to Fulton County, Georgia, to watch a case that is literally one of the most disturbing cases I've ever watched. It's infuriating, actually. A guy is pleading in a case where he was charged with sexual assault of a child under 16. And who needs the defense attorney when the judge and the prosecutor break their neck to find ways to get this guy off of any kind of penalties? It is infuriating, and I want to know what you guys think. Drop your comments below. Let me know what you think about it. It's just crazy. It's one of the craziest cases I've ever seen. So get your popcorn, get your pop. You got a hot cup of coffee. Let's watch this travesty unfold. And drop your comments below. I want to know what you think about this case. Court is in session.
Which Mr. Stargell is now charged with sexual battery against a child under 16. Who will be handling things for the state? Ms. McGillicuddy?
I am.
All right. And Mr. Stargell is here, represented by Mr. Steele and Mr. Rousey. I'm open to having both of you speak as long as you don't speak simultaneously so that Ms. Rivers can take that down. Ms. McGillicuddy, I'm going to start with you. If you would let me know, please, what the plan is. I've been privy to some email traffic about a hearing on enforcing a deal, a lot of briefing about that. Then maybe we have a plea, then we don't. Judge Dunaway has been subpoenaed. Is he going to have to testify? Now there is potentially a negotiated plea that doesn't seem to give the judge much leeway into anything. But it's the last I heard, that's where we are. I'd like to hear from you where you think we are.
Yes, Judge. So where I believe we are is that the defendant, Mr. Stargell, is entering a plea to sexual battery against a child under 16 under the new reaccusation number as he's waived indictment 26 SC 002043. The recommended sentence is going to be 5 years probation to that charge with no contact whatsoever with Clair Hicks or her family. And that's CLAIRE. Hicks is HICKS. He needs to, while on probation, complete an anger management course. He needs to abstain from drinking, can't consume any alcohol or drugs while on probation. He has to submit to testing by probation with a Fourth Amendment waiver. And I believe it is my anticipation that defense counsel is asking for him to be treated as a first offender. I've reviewed his criminal history. He is eligible. And I believe that should summarize things. And this is being offered to resolve the case in lieu of the hearing that was otherwise scheduled for today.
Okay. And I think it's a NOLO plea. Is the state opposed to a NOLO plea?
I'm going to leave that to the court's discretion, as well as I anticipate them asking for sealing of the record. I leave that to the court's discretion as well.
Okay. And what about first offender?
He's statutorily eligible for first offender, so.
But that doesn't mean you have to embrace it.
I'm willing to accept the plea, or willing to not contest first offender treatment based on the fact that he has no criminal history.
Okay, well, I hear you on that. Does your office take a position as to whether he should, I'm going to assume for a moment he's eligible. We're here if we have pretrial services or whatnot. What's your office's position on whether he should nonetheless be sentenced? It's still discretionary.
No, I understand your question, Judge. The state does not have an objection to him being sentenced as a first offender.
Okay. All right. And I think Mr. Steele and Mr. Rousey will go into more detail, but I think there's also some agreement that the state has that if this plea results in Mr. Stargell being required to register, then he has kind of filed or will file this conditional motion to withdraw the guilty plea. If it doesn't go as well as I hope, then I get it back out of it.
So this is the state's position on that matter. And we've had lengthy conversations. Are we on the record currently?
We are. Ms. Rivers is taking this all down.
I just wanted to make sure, because I did want to put this on record anyway, and it saves me from repeating it twice for you. I've had extensive conversations with GBI, and their Department of Sex Offender Registration, as well as with Captain, April Woods over at the Sheriff's Office, who deals directly with this office on behalf of the Sheriff's Department and would be overseeing the direct, result of this particular plea. I realize that while part of the statutory scheme references 1710 6.2 and offenses that require statutorily someone to register, that would be if it were a second in life felony sexual battery plea. But then there's a more broad statute, obviously, that references other situations where it seems that registration can be just a little bit discretionary depending on interpretation. So I've gone out of my way to try to figure out and get a firm answer one way or the other so that we can all be assured that there are no unintended consequences of this plea. I am confident, and I've expressed this to both defense counsels, that he will not be required to register as a result of a first in life felony sexual battery plea. And I've confirmed that with the captain at Fulton County Sheriff's Office. I understand that they have reservation about that. But to the extent that I felt like I could maybe mitigate some of that reservation, I've also prepared an order, because one of the things that GBI indicated is that a judge can order that sentence did not contemplate a requirement to register. So I've prepared that for your honor's consideration.
Okay.
I think I've really done as much as I possibly can to put those fears to rest.
Okay.
That would happen unintendedly.
Okay.
So
And it's
I'll let
not
you
your
know.
intention that it should happen.
Correct.
It's your expectation that statutorily it ought not to happen.
Correct.
Maybe there's this area where someone could, out of his or her discretion, say, you know what, I think it fits in this case. But then you've got an order that would further eliminate that possibility.
Correct.
Okay.
And I think that should sufficiently overdo it in terms of really making sure that that doesn't happen, because I think statutorily it should not happen.
Okay. All right. Thank you. That's helpful orientation. Counsel for Mr. Stargell, any orientation you want to provide me before we move forward with the plea colloquy?
I don't believe so, Your Honor. I think that as we go along, we could answer certain things. I did think that we have an agreement that it would be a nolo contendere plea, not leave it up to court. I'm not saying the court wouldn't take a nolo plea. I'm just saying I thought the parties agreed to that. I heard what the district attorney said just now. I'll look for the email. Maybe my memory is wrong.
We could have a separate motion to enforce the nolo plea if we need to.
There you go. And then as far as, yes, we have concerns. It's just the district attorney has given us a email with an analysis of the law, which I really appreciate, and we looked at. And it may be perfectly correct, so Mr. Stargell will not be on a sexual registration. If he winds up on one, I can't say, well, the district attorney did this work and said this. So I have cases that I share with the district attorney from other lawyers that sexual battery first offense does wind up on sexual registration, even with a first offender. So I'm concerned, but we're going to release that concern if the court embraces it with I think I heard you argue one day against me, talked about, without Judge Goga, belt and suspenders. So I'm trying to do belt and suspenders that we will file timely. We're not trying to act on it, but a motion to withdraw the nolo plea will go in tomorrow. And we're not going to ask for it. And it's going to be one thing. It's going to say, if Mr. Stargell winds up on sexual register, then based upon the agreement, if you embrace it, of the parties and understand the court, he will then withdraw his nolo plea. And we understand at that point, he can go to trial. I mean, the case would be reborn. We get that part.
Right.
Anyway, other than that, it was accurate what the district attorney said. And I'm not saying that it was accurate. I just want to check the nolo plea.
Okay.
My memory is it was an agreed upon part of our agreement, not that it was going to be submitted to the court.
All right.
Oh, and also sealing of the First Offender Act. We're going to ask if you sentence as a first offender that you seal it today, please. That's what we'd like. And then restrict the other case, which is the indicted case, which should be 25 SC 0000407. If you sign the order of no pros, which we have no objection to, if you would seal that case as well today.
Okay.
And from speaking with the sheriff's office in Fulton County and the GBI, both lawyers for each entity, they did not give me advice, but they told me, you got to be careful because the charge right now is rape. And if that shows up, we treat it. We don't care what you plead to. We care what the facts are. So the more you can erase, quote unquote, the rape, the better it's going to be for you down the road. And they said that they are not, I was told they are not bound by what the court says. They follow the statute, and probation generally is the driving force. So I just got concerned.
Okay. I appreciate your concerns. Ms. McGillicuddy, there was one other question I meant to ask you. There is the possibility that someone has to register. There are also a litany of special conditions that someone has for certain sex offenses that is independent of whether you have to register or not. Is this an offense where that separate roster of conditions of probation applies?
Talking about electronic monitoring or not electronic monitoring, the use of electronics acknowledgement and
That's one of them, but when
I know.
some pleas I take or sentences imposed after trial, probation comes to me and says, there's this whole separate set of conditions. You can't dial a, 988 number. You can't pick up hitchhikers. And some of them I get, some of them are rather antiquated or aren't really related to maybe but it's a different set of probation conditions. The future probationer has to sign it, probation signs it, and I sign it saying yes. And I can go through and strike some of them out, like it's okay for you to pick up a hitchhiker that's unrelated to what happened here. That's not, to me, coextensive with when you have to register. So I want to make sure that that's not a tripwire here and we all have to rush back together in a few days because someone wasn't expecting it and it lands in his lap.
no, Judge, and that's something I also specifically addressed with Captain Woods.
Okay.
Was the additional number of additional conditions that go with that, and those are typically to her implementation of them commingled with registration requirements.
Okay.
So she, I'm treating her as the final word sort of on this because she's the person overseeing it with the sheriff's department, and so she would be the one to kind of direct probation.
Okay.
On that point.
Ms. Simpson, I don't mean to put you on the spot. This is my probation expert. She's with Department of Community Supervision, so she's the one who hands me these things. This is less about registration and more about that separate set of conditions.
Yeah, Judge.
Ms. Simpson, do you have any perspective on, or someone you'd want to reach out to as to whether, and you know what I'm talking about, that collection of special probation conditions that apply to sex-related offense, whether those would be in play in Mr. Stargill's case if we go forward with a plea to this accusation?
Judge, so I can get with the assistant chief who is over our sex offenders unit and ask her, but this kind of actually ties within a similar situation that I brought to you earlier. If you put it in the disposition that the defendant is not obligated to the probation, sex offender special conditions, then the officers will follow along with that and they won't hold that person to it. But if for your justification, if you want, I can verify that with the assistant chief just to verify that. But if you're not requiring that person to be tied to our special conditions, then if you just put that language in the order, then that would suffice. us.
Okay, yeah, please do double check. That's what I remember you telling me. And I think that's a way, in particular with this piece, Mr. Steele, where it would be probation conditions and not what does the statute say about having to register. If both sides agree and I concur, then it's probably smart to put that in the final disposition.
And that's why I did the sentencing order.
That as well, but in the final disposition, which is where DCS would be looking if there's language. If I think it makes sense to say, and I'll want to just get that language from Ms. Simpson, because then we'll be referring to that collection of conditions by whatever the official title is, so they'll know what we mean. Hey, did you fix the jury camera?
Oh, yes, we just turned it on, we're gonna remote into it, see if it's working.
Thank you so much. Appreciate it. That's just a way to address it. And it doesn't sound like that's something you're pursuing. So if I decide they don't apply, it won't be over the state's objection.
Right, correct.
Okay, all right. Lots to
Judge,
clear.
could you, just to clarify, could you give me the new charged offense so I can make sure I give it to her correctly?
Yes, ma'am. It's sexual battery against a child under 16. It's OCGA 16-6-22.1, subparagraph D, as in Delta.
Thank you, Judge.
Thank you. All right.
Judge, the last piece I have is the motion to null pros the other indictment that I can present after we've gotten through the plea portion for the accusation.
Okay, and my plan and how I typically do it in this division was that I was going to ask you after you were done, do you move, and you just move on the record and then we can, but if you also want it documented, which is fine, then you can get that motion to me and we'll get it taken care of.
Okay, I brought everything with me. So.
Good, be prepared.
Do you want me to approach with these two pieces, the signed accusation?
You can, actually, you're going to be right here for the plea colloquy because the court reporter is remote. Mr. Stargell and one or both of his lawyers will be at the podium and you'll be at the witness stand so she can see you, but then you and Mr. Stargell are looking at each other so he's not having to turn backwards to answer your questions. So you can just bring that up when you come up. All right, I think we're ready to move into those positions. So Ms. McGillicuddy, if you'd come up to the witness stand, and Mr. Steele and or Mr. Rousey, and most importantly, Mr. Stargell. And Mr. Stargell, you stand in front of the screen there, please. Let me know when you're ready. Oh, and you have my papers?
Yes, I do. Let me make sure I give you the right one. Actually, hold. Let me give it to you.
Okay.
Just a second.
You good?
Do you let me swear him in?
I'll let you know exactly what's going to happen. I just don't want to start till you're ready.
Nope, we're good.
You're good? Okay. We're already on the record. Mr. Stargell, in just a moment, Ms. McGillicuddy is going to put you under oath. Once you're under oath, she will ask you a bunch of questions, all of which I'm sure Mr. Steele and Mr. Rousey have covered with you, but you need to give those answers completely and truthfully. If at any point during the conversation we're having, you have questions of your own, you should let me know. If there are things you need to discuss privately with your lawyers, you can step back from the podium. They may just be, I didn't hear what you said, or what does that mean? And then you let me know. But I won't know that you have a question unless you verbalize it or you nudge your lawyer. And it is fine to stop the proceedings to get your question answered, okay?
Yes, Your Honor.
All right. Ms. McGillicuddy, when you're ready.
Mr. Stargell, please raise your right hand. Do you swear and affirm that the evidence and testimony you shall give in the matter now pending before the court will be the truth, the whole truth, and nothing but the truth?
I swear.
All right, you can put your hand down. Please state and spell your true and correct legal name.
My name is Andrew Stargell, ANDREW STARGEL.
Are you at this time taking or under the influence of any alcohol, drugs, or other medication?
I am not.
Is there a medication that you normally take that you have not taken today?
No, ma'am.
How old are you?
I'm 19 years old.
And how far have you gone in school?
I'm in my third quarter of my freshman year.
Are you able to read, write, and otherwise understand the English language?
Yes.
Do you understand that you are charged in reaccusation 26 SC 002043 with one count of sexual battery against a child under 16 pursuant to OCGA 16-6-22.1D, and that is a felony offense?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you pled not guilty or remain silent and chose not to enter a plea, you could have a jury trial on that charge.
Yes.
Have your attorney spoken with you about the rights that you're waiving in order to enter a plea today?
Yes.
All right. And we're going to go over them too. I just want to make sure you've been spoken to about them. Have you had enough time to speak with your attorneys, Mr. Steele and Mr. Rousey, about all of the facts and circumstances known to you about your case, as well as any potential defenses you may have?
Yes.
Do you need any more time to speak to your attorneys?
I don't think so, no.
Okay. Are you satisfied with the services that they've provided you?
Yes.
Counsels, and I'll start with you, Mr. Steele. Are you satisfied your client has a full understanding of these proceedings?
I do.
Okay, Mr. Rousey.
I am.
Mr. Sargel, have you looked over the new accusation of the charge in your case?
Yes.
Okay. And is that your name at the top of that accusation? It's right here.
Yes.
And did you indicate your plea on the front of that accusation?
It's the one we signed, no.
Yes.
Okay. And are you waiving a formal reading of this indictment?
The accusation will waive formal reading.
Accusation, that's what I meant. And are you waiving any and all defects in the accusation for the purposes of the plea?
So waived.
Okay. And I know, I believe this was filed in conjunction with the accusation, but since it was just done today, have both of you waived arraignment and waived indictment for the purposes of this new accusation?
We've waived indictment and we waive arraignment.
Mr. Sargel, were you originally arrested for this charge back
Yes.
on the original indictment?
Yes.
Okay. And Judge State's unaware of any other outstanding warrants as it pertains to this case? Do you understand you're entering a plea to sexual battery against a child under 16?
Yes.
Have your attorney spoken to you about the minimum and maximum sentence you can receive for that charge?
Yes.
Do you understand that this is what's considered a negotiated plea, which means the state is making a recommendation to the court? It's the same recommendation that your attorneys have discussed with you, but that the court makes the decision about whether or not to accept that recommendation?
Yes.
Okay. Do you understand if you're placed on probation, you cannot violate any criminal laws of any governmental unit or any of the conditions of your probated sentence? Do you understand that?
Yes.
And do you understand if you do violate any of those conditions or break a law, probation can file what's called a motion to revoke your probation, which is a petition, and that you could be placed in custody for violating the terms of your probation. Do you understand that?
Yes.
Do you understand that if you're charged with a crime in the future, they could use this plea to enhance your punishment in a future case? I'm not saying you will, but if you did.
Yes.
Okay. Do you understand that if you were currently on probation, they could use this plea to revoke that probation?
Yes.
Do you understand if you are not a United States citizen, any guilty plea you enter would affect your immigration status up to and including removal?
Yes.
That doesn't apply to this. Do you understand there may be other adverse or unfavorable consequences of entering a guilty plea, just like there could be if you were convicted after a trial?
And I don't mean to interrupt, but it's a NOLO plea.
Yes.
Should have known that. Okay.
Okay. Do you understand that there can be other unfavorable consequences of entering a plea, just like there would be after a conviction?
Yes.
Do you understand that because this is a felony offense, you can't use, receive, possess, transport, or own a firearm while
Yes.
you're on probation?
Yes.
Okay. And it's my understanding you were asking to be treated as a first offender. Is that correct?
Yes.
Okay. Have you ever pled guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Have your lawyers explained to you what the First Offender Act is and what it means?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you would be adjudicated guilty, and you could be resentenced up to the maximum for the charge that you're earning a plea to?
Before Mr. Stargell answers, may I just pose an interjection for a moment?
Sure.
I don't mean to interrupt you. Because it's a NOLA plea, he would not be pronounced guilty, but the judge could resentence him.
Right. But do you understand, the point I'm getting at, Mr. Stargell, is do you understand that that would open you up to what's called resentencing, which means the court would not be bound by any prior negotiations. It would be, you would be able to be sentenced all the way up to the maximum for that charge?
Yes, ma'am.
Okay. All right. Do you understand that you're waiving any and all defenses, including mental health defenses, to enter this plea?
Yes.
And I have to go over the rights that we talked about at the top. I know your attorneys have already gone over this with you, but I have to ask you one at a time. And so if you could just verbally say if you understand you're waiving each one.
Okay.
Do you understand you're waiving the right to a trial by jury?
Yes.
Do you understand you're waiving the right to remain silent and not incriminate yourself?
Yes.
Do you understand you're waiving the right to see and hear the witnesses called against you and question them if you chose?
Yes.
Do you understand you're waiving the right to the assistance of counsel hired by you or to appointed counsel if you could not afford an attorney?
Yes.
Do you understand you're waiving the right to the presumption of innocence, which means the state would have to prove you are guilty of each count in order for you to be convicted?
Yes.
Do you understand you're waiving the right to testify on your own behalf or to remain silent, and the jurors will be instructed they can't use that choice against you?
Yes.
Do you understand you're waiving the right to present other evidence of your own and call other witnesses if you chose to?
Yes.
Do you understand you're waiving the right to appeal if you were convicted of these charges after a trial?
Yes.
Has anyone, oh, before I get to that, Mr. Steele, are you satisfied your client understands all the rights I just went over with him?
As far as I could tell, absolutely.
Okay. Mr. Rousey, are you satisfied he understands?
Yes.
Has anyone forced, Mr. Stargell, this one's back to you. Has anyone forced, threatened, or promised you anything to get you to enter this plea?
No.
Is it your decision to waive these rights and enter a plea because, well, he's entering this under Alford? Okay. So I'm gonna ask you a different question. Are you pleading because you have decided it's in your best interest to enter a plea?
Yes.
All right. And are you aware that, well, strike that. As to accusation number 26 SC 002043, with that sole count being sexual battery against a child under 16, how are you pleading to that charge?
No, contender.
Nolo contendere.
Okay. Under first offender, correct?
Yes.
Okay. And is that plea being freely and voluntarily made with full knowledge and understanding of the charge against you?
Yes.
I'm going to go over this part only because I know we've talked about it, but I'll go over it anyway. You do not have the right to appeal directly from your plea, but if you believe there's some error in your plea, you can apply to the appropriate appellate court to request a discretionary appeal, and that has to be done within 30 days of today, and that's found in OCGA 5-6-35. You understand that?
Yes.
And do you understand that you have 4 years from today, because it's a felony charge, to file what's called a habeas corpus petition, which challenges the voluntariness of your of your plea?
Yes.
All right, Judge, I believe that concludes the colloquy. Did you want to hear the recommendation again or the factual basis?
Factual basis. I think I got the recommendation. I have a couple questions about it, but let's do factual basis. And then I'm going to want to hear what, if anything, Ms. Hicks and her family have to say.
I have that here, Judge.
Okay, I know
To read on
there are some folks here too, and so if they want to be heard, I will certainly hear from them as part of the process, but
They
we'll-
are, unless they've changed their mind. I believe they had provided me with a statement that I can provide to
Okay.
the court.
we'll
That's,
check in with everyone at the appropriate time. Why don't you start with what you think the facts are in the case?
okay. They have an attorney with them as well that he may read it instead. So I'll do the factual basis first.
All right, one step at a time, factual basis.
Okay. This incident occurred back on August 4th of 2024. That's when officers were responded to Children's Hospital of Atlanta. The victim in the case, Claire, was 15 years old. This defendant is an older brother of her friend. She had come to Children's Healthcare of Atlanta for a sexual assault nurse exam, as well as a forensic interview. She had gone to her friend, the younger sister of this defendant's house, to stay the night. They were in the basement. It was her, the younger sister of this defendant, and one other friend. And
Also female?
Yep. Yes, Judge. And this defendant came home. He had been at a party elsewhere. His father had gone to pick him up. He was 18 years old at the time and brought him back home. He went into the basement.
Do you know why his father had to pick him up if he was 18?
Because he was drunk.
Meaning
Because he was intoxicated.
Mr. Stargell,
Mr.
defendant,
Stargell,
was?
Yes. He gets back home and goes down into the basement and is sort of hanging out with the girls, his younger sister and the two friends, one of whom was Claire, and trying to get them to drink. So they're consuming alcohol. Annie, the younger sister of this defendant, goes up to bed. The two girls remain in the basement, Claire and the other friend. The other friend is sort of outside of the basement on the phone, I believe with somebody she was seeing at that time. So
There's another boy
No.
down there.
no.
Oh, you said
the
she's
phone.
on the phone. Got it. So she's talking to a special friend.
Correct. And Claire and this defendant are in the basement. At some point, Claire decides she's going to go up to bed as well. And she goes to go up the stairs, to go up to where Annie's room is, where she's going to be sleeping. And this defendant comes behind her up the stairs, gets her to pulls her into his bedroom. And then what Claire can remember is that things started to get sort of fuzzy, and she began to black out. She remembers saying that she didn't want any of this, and she remembers sort of opening up her eyes, and that this defendant said that he would buy her Plan B. A lot happened the following morning with regard to this defendant, and then his mother coming in the room to say that she could hear what had been going on in the bedroom the night before. But essentially, Claire called her brother, told her brother Luke what had happened. Luke took her to another person they know who is a nurse. She spoke to her, and then ultimately told her parents, and ultimately winds up at Showa for these exams. There was DNA located. It was a YSTR match that could not exclude this defendant as a contributor. The rate of match was 1 in 29,000. And so search warrants were obviously obtained for buccal swabs to do comparisons and so on and so forth.
Sure. That level of match, was it because there was such a small amount they were recovered from the exam kit, or that's not I don't want to say a typical result, but sometimes it's 1 in 82 quadrillion chance that it would be someone else, and we say it was that person. But when it is fuzzy like that, what's the science behind that? That there wasn't much, or it was. I'm trying to understand that.
It's just the quantity and the availability of the quantity to be able to get something more than a YSTR match. A YSTR match, while still pretty typical in sexual assault or rape cases or any type of sexual case, YSTR is going to be limited to that person. So in this case, Mr. Stargell, or any male relative of Mr. Stargell. So that's where the proportions and the probabilities get a little bit weaker, but not so much that they would not still be admissible in proving his identity at a trial.
And it certainly wasn't a no match, no connection.
Correct. And based on the findings of the kit, that's what created the subsequent indictment. What I can say from my part is that this case had been assigned obviously to another judge and another prosecutor. I took over this case in probably December, January, as a supervisor to just sort of review the prosecutorial decisions that have been made on the case. And what I ultimately did was spoke pretty extensively with Claire, and then with her family as well. I know that Miss Hicks and others are very disappointed that the final recommendation in this case does not include house arrest. I would say that I still feel like this is a well thought out resolution, based on everything I know about the case, based on the conversations I've had with Claire, based on the conversations I've had with defense counsel, based on the defendant's position, based on his age, based on the facts in general of the case. I've really spent a good deal of time with this case to be thoughtful in my recommendation. I know it's not what defense counsel wanted either for their client, which was the reason for the motion to enforce what they believe to be a prior offer. So I realize that it's not exactly what they had wanted, but I do feel that it is an appropriate result nonetheless. And that's all I have for a factual basis, Judge, and I can just kind of look back and see if I am going to present the email or if, do you want me to read it or?
May I approach?
Yes, if you're going to be the reader, if you'd come up to where Ms. Williams is seated, and she will move over one seat, that way, or just abandon the table. And if you would get your name into the record for us, explain your connection to Ms. Hicks, and then share whatever it is that the Ms. Hicks and the family want shared.
Good afternoon. My name is John Garland. Claire Hicks has brought me in to advise them through this process in her role as the victim in this case. And in doing so, they've asked me to read this statement and also share a few additional things with Your Honor. So first, I will read the statement. Based on the heinous events that occurred on Sunday, August 4th, 2024, our family has endured 626 days, 89.4 weeks, 1.7 years of profound suffering, processing, healing, fighting, and rebuilding. We have surrendered this traumatic event to our faith and justice system. Further impact details are private and unnecessary to share with Claire's abuser. Today marks an opportunity in our journey to depend on our justice system to support, advocate, and gain justice for the victims of sexual assault. Thank you to the court and to our attorneys for fighting for justice for Claire, the Hicks family, Jay, Michelle, Luke, and Claire. And I wanted to share a few additional things with Your Honor. As the state alluded to, the Hicks are disappointed that the offer does not include home confinement. They do wish Your Honor to accept the plea today. They do wish Your Honor to move forward so they can move forward with their lives. But they are very much opposed to the entry under first offender. And they also would ask Your Honor to consider the special sex offender conditions. And I know Your Honor has the list, and I can go over through them with you if Your Honor would like, of the ones that they have indicated they feel are appropriate. But we could address that at whatever appropriate time.
Okay, now would be the time, because my question for you, Mr. Garland, was going to be, in your client's mind, what does justice mean? Because they said it's the time for justice, and you've started to steer me towards that with the, hey, house arrest, and maybe some, but not all of the conditions that would be in that collection of special conditions. So I am interested, based on the family's experience and with this traumatic situation and their deep thinking about it, which of the provisions they think are most apropos to this situation.
And if You're on, I apologize. I quickly pulled out the standard list to go over with them, and I left it sitting.
Why don't you head on back there and grab it?
So the first one that will typically come up on a list is contact with minors under the age of 18. And they believe that that would be an appropriate condition in this case, given the nature of the facts. Another condition that seems unlikely to occur but would be appropriate if it were to occur was preventing residence with a minor. And if my list is different than yours, please, stop me.
No, what I'm asking you to do is just, and it sounds like you're doing it, you're skipping over the ones that you don't think are an issue. It doesn't seem like a case where anyone's access to the internet needs to be restricted, so you probably won't mention those. But like I said, I'm very interested in what the family thinks is appropriate given what they've been through, in particular, Ms. Hicks.
They do have concerns about, the typical condition of any visual media of minors depicting sexually explicit conduct. Of course, that's prohibited by the law anyways, but can often be included as a special condition as well.
You have no reason to believe that anything that happened on August 4, 24 was filmed or recorded in any way?
No, Your Honor.
Okay.
Tying in with the, disappointment about the home confinement is having some type of curfew, even if it's not a full home confinement, a potential curfew as well, which is, one of the standard sex offender conditions that's often imposed. I'll skip over some of these other ones. Other ones in here have already been mentioned, such as alcohol, drugs. They prefer drug screens and alcohol screens, given that this was alcohol related, according to the state's allegation. And those are the ones that we're requesting, Your Honor.
Okay, I appreciate that. Family, I just want to confirm what Mr. Garland relayed is what you wanted to have relayed. Yep, I'm seeing lots of nodding. Okay, thank you, Mr. Garland.
All right, thank you, Your Honor.
Ms. McGillicuddy, I had, as the conditions of probation you were requesting, I think they were negotiated, but Mr. Steele and Mr. Rousey let me know if they differ. Obviously, no contact with Ms. Hicks or her family, direct or indirect. Anger management, my shorthand for it is drug and alcohol abuse evaluation and treatment, but I'll manage that piece. No alcohol consumption while under sentence, Fourth Amendment waiver. You didn't say anything about community service, which surprised me. And then I remembered what the offense is, which makes it difficult for people sometimes to do meaningful community service, because when you tell them why you are on probation, they say you can't help here, even though it might be totally appropriate for Mr. Stargell to work with a group of kids who are doing X, Y, or Z that's unrelated to this. So I think I'll probably stay away from community service. But did I capture, for the most part, what you had asked for?
Yes, Judge.
Okay, all right. We have on the call Ms. Gordon from pretrial. Ms. Gordon, can you share with me what criminal history information, if any, you have for Mr. Stargell?
Good afternoon, Judge. The GCIC indicates the defendant has no criminal record on file. Nothing further.
Thank you, ma'am. I appreciate you joining us. You are free to go, and you're welcome to stay on, but this is our one matter this afternoon.
Thank you, Judge.
Thanks so much. Thank you for those. Mr. Steele.
Yeah, I want to thank the court. I want to thank the district attorney's office. I'm not so sure. I've litigated a lot, like the court has and all the other parties here, but I'm not so sure. I've had a disagreement intellectually, it was not personal, on having a deal. But the district attorney's office, who at least one is present, there was Ms. Peterson, I don't know if she's still in your courtroom, but they were very professional, and we all thought it was in the best interest of Mr. Stargell, my interest, Mr. Stargell, Mr. Rousey's interest, and the state's interest for Mr. Stargell and the alleged victim if we find a way to resolve it. So it was tough because we thought we had an agreement, which the court is aware. That's why we filed the motion. But I want to thank the district attorney's office. This is really a tragedy. So Mr. Stargell's 18 years of age. on the 4th day of August of 2024. The alleged victim is 15, and the court knows that within the 4-year period under relevant statutes for misdemeanors. The reason we're asked for and have an agreement with the district attorney's office, please correct me if I'm wrong, but we have an agreement to no plea, is because Mr. Stargell, I never thought we'd be here. I thought we'd be at a trial. So he's not pleading guilty. In fact, he's maintaining innocence, as you heard from the Alford plea during the colloquy with the district attorney. Mr. Stargell comes home. He is not knee walking drunk, but he's intoxicated, can't drive. In the home are his 2 parents are in your courtroom, his brother, his sister. His sister has 2 friends over, the alleged victim and another young lady, Maddie. Just leave out the last name, Maddie. And Maddie is good friends with the alleged victim, is good friends with Mr. Stargell's sister. And the 3 girls are in the basement. Mr. Stargell comes home, goes into the basement with his father tells him, "You're not staying in the basement, get upstairs." Maddie tells the police, when she's separated from everyone with her parents there, with permission of her parents to be interviewed by police, she's also 14, 15 years of age, that she never saw Mr. Stargell give anybody any alcohol, including the alleged victim, never heard anything inappropriate. And Mr. Stargell went upstairs by himself. Mr. Stargell would testify if we were going to trial that that's what happened. He was in his room. It's a separate room than his sister. Maddie stays downstairs. She's sleeping in the basement. She's awake. She's on the telephone. She never hears a struggle. She never hears an outcry or a scream. Same with the parents, same with the brother, and same with Mr. Stargell's sister, who's also on the same floor because she came upstairs and did not stay downstairs in the basement to sleep. In fact, there was giggling being heard from Mr. Stargell's room. Mr. Stargell states that the alleged victim was the person who was the aggressor, and they had consensual touching, but there was never intercourse. We consulted with a DNA expert who the court I know is familiar with, at least I believe the court's familiar with, if it remembers, testifying via Skype or Zoom in a trial before this court. I was not involved and I did the appeal, but Greg Hampikian, and he explains that of course there's going to be DNA when the GBI, when the rape kit is done, because she being the alleged victim is in the bed of Mr. Stargell. So we would of course believe that we'd find small amounts of DNA, but there was no intercourse, anal intercourse, anything like that. Mr. Stargell has a girlfriend at that time. The alleged victim leaves his house. She is fine. Maddie tells the police she knew nothing about being sexually assaulted or anything bad happening. She saw her friend that morning when she left the house, and the friend was in a good mood. And all of a sudden we have this outcry, and the alleged victim calls Mr. Stargell's girlfriend and says that your boyfriend's cheating on you. I don't know how we get here, but we're here. So Mr. Stargell is in college. He is doing well in college, and he doesn't wish to go to trial. The state has told us that if we don't enter this plea, they did not threaten us or anything. They just told us as a courtesy, they're going to re-indict the case and add all the charges that you can think about, which I could think about, which according to their belief may be appropriate under statute. And then we let a jury decide, and Mr. Stargell doesn't wish to do that. He is very young in age, but he has grown up a lot. He's an athlete also. He does not drink alcohol. This is weighed on him. I'm confident it's weighed on the family of the alleged victim. I heard what they said, but it's weighed on Mr. Stargell and his family as well. He is worn out. He has lost opportunity after opportunity. He went through a temporary restraining order hearing that Mr. Rousey and I defended him out, where the judge dismissed it, where she said he's not coming around the alleged victim. In fact, the allegation with Mr. Stargill's at a gym that he's been at for years. And the alleged victim decided to go to that gym. And then Mr. Stargill was there. She saw him, and then she said that he can't go to that gym anymore. And the judge said, that's not what we do here. He didn't stalk you, go around you. He was already in the place before you came. Same thing, Mr. Stargill working. He works in an area, he's outside. He helps out a person who's older and is infirm. He's been doing that. And he's at the house, and the alleged victim is in the neighborhood taking a walk, and she sees him there, doesn't want him working there. And the judge for the temporary restraining order hearing said, he's been doing that for years. He's not coming around you. You're walking, you see him outside, walk the other way. The point I'm trying to make to you is both families here are under tremendous pressure and strain. And this is something that Mr. Stargill would like to put behind him. We did not agree. We have a total negotiated plea based upon, well, first of all, it's the right thing to do. But second of all, based upon our prior dealings where, we have to go back to Mr. Stargill and say the plea agreement that we told him, whether right or wrong, was agreed to by all parties and would be given, and we made that announcement to the Honorable Judge Dunaway, your predecessor judge. That's no longer here. So, there's a sense of how's that possible? So we put everything in writing. It did not ever contemplate. There was never a conversation, a discussion of asking for no contact with a minor under 18, preventing a residence in a minor, with a minor, his sister's a minor, a visual median of minors, or a curfew. That was not discussed. So we are opposed. If you take the plea, if you don't take the plea, we understand that's within your breast. I'll answer any of your questions. Mr. Stargill's family's here. They said they have been through it. I told them that your Honorable Court invites people if they want to speak. They said no, but if you want to hear from them, they are here. But they said no, just they are ripped apart. They don't wish any harm on the alleged victim or her family. They don't wish any harm. They just hope that everybody can understand that whatever happened, hopefully will never happen in the future to anybody, and the families can enjoy a peaceful and productive life.
Mr. Stargill, where are you a student?
I play football at Georgia Military College, sir.
Are you also a student there or just a football player there? Okay. How long have you're in your third quarter?
Yes, Your Honor.
Okay.
Actually, if I may, you may want to, can you may I have one moment? The judge didn't ask, but can you just tell me your grades?
I applied for Hope. I actually just got a Hope scholarship, but I've got I think I have a 3.5 GPA. Got my grades up. I get all A's and B's.
Great.
Do everything I was supposed to.
Good stuff. You have one younger sibling, your sister?
Yes, Your Honor. And I have an older brother. That's a junior in college.
Okay. Is there anything you want to share with me about anything you've heard here today? You don't have to say anything at all, but among all the people in the room, you have the most absolute right to be heard because it's your plea and sentencing, if there's anything you want to say.
I did not do this. I did not do what I'm being accused of. I do not have that bone in my body to do something like this. That's all I have to say.
Okay. Tell me, as best you understand it, why it's important for this to be a nolo plea as opposed to an offered plea. And I don't mean this as a quiz or a trap. I'm going to bug your lawyer about it anyway, but he's very, very insistent on it. I'm trying to work through it because we don't do many nolo felony pleas. It is typically, I didn't do it, like you said, but it's in my best interest to enter this plea. We call it a best interest plea, which is the same as an offered plea. But a nolo, I don't see those that often. So it's moving me into a slightly different space with a serious charge.
Yes, Your Honor. So you want me to answer what, in my understanding, what a no low plea is.
Yeah, and why that's important to you as opposed to what you said, and I appreciate the significance that you said you didn't do it, and you still don't want to go to trial, and you think it's in your best interest to resolve the case in this way. We'll call it negotiation number 2. And I understand that. I also understand why Ms. Hicks and her family see some benefits of not going to trial, because she's not put through something and doesn't have to tell 12 strangers about something she doesn't ever really have to talk about to anyone. But NOLO is different from a best interest plea. And I'm wondering what you think the difference is and what the significance is to you. And you can say, I have no idea, I'm doing my lawyer's say, and that's okay.
Off the top of my head right now, I can't give a great description of it. But if I'm reminded, I could tell you easily.
Okay.
That is not a conviction.
Not a conviction.
Okay. Nor is an offered plea first offender. But let me talk with Mr. Steele about it. Because again, I won't rely on you, but Mr. Steele was very insistent on it. And so I thought maybe it had a particular significance to you as well.
For sure.
So Mr. Steele, walk me through what you think the significant difference is for your client if this is a NOLO plea versus a first offender offered plea.
NOLO plea is better than first offender and offered because under Georgia law, statutory is under Green, Green versus state, which maybe 2021 case, it is not a conviction. And that's by statute. And you could get certain jobs, you can go to certain schools, you can live in certain places that otherwise you can't, even with a first offender. It's not recognized by certain federal agencies, maybe all federal agencies, but I don't want to say all. And an Alfred plea, we are tendering that as well. So it bodes both ways. But you have to understand, and I appreciate the question very much. Thank you for asking. Where we were. So when we believe that the offer was misdemeanor sexual battery, which fits the scenario if there's consent, that took a lot to get Mr. Stargell to agree to.
And was that going to be a NOLO plea or that was a plea? I did it. I plead guilty to misdemeanor sexual battery.
We were talking about a NOLO plea on that as well.
Oh, but now you're talking about gets even fuzzier than I swear to you there was a deal.
Let me finish.
Okay.
Mr. Stargell that was a hard pill for him to swallow, the misdemeanor, because he believed that these facts don't add up to anything. But when we went over the law, and whether he likes it or not, the law says that this type of touching meets this misdemeanor. So we were okay with, I was asking for a NOLO plea. We were okay with a guilty plea. It didn't matter. It was the fact that it was reduced. And the indictment would be no pros, it would be an accusation to this misdemeanor. All the other terms didn't matter to us. When that got challenged, and then we had to file a motion, and then the district attorney who's seated to your left, and Mr. Rousey and myself agreed upon the felony sexual battery, it became paramount that it would be a NOLO plea.
And why is it paramount? I guess the disconnect for me is I've always thought, and typically thinking about eligibility for federal programs, that a first offender plea isn't a conviction. That's what we tell people. And you nod your head, and Mr. Rousey nods his head when I say that's not a conviction. When you leave the courtroom, you don't need to check any box that says you're a felon, because you're not. And as long as you successfully get through the period of probation, I don't have any doubt that Mr. Stargell isn't going to apply himself to get through that period of probation. And if he is who he says he is and you say he is, then he's going to get through it just fine. He ends where he began, which is with no conviction.
No, but what I was trying to finish is a first offender Alfred plea does not protect him from a civil lawsuit or his parents, and it happened on his parents' property. And we don't want to give an inch I don't do civil work. But in case there is a civil case coming, everybody will start and have their trial on a civil arena, even not to explain, well, let me tell you why I entered a guilty plea. However, I did maintain innocence and it was protected on First Offender Act. Because, see, originally I wanted to go to trial, but then I learned that it's 25 years to serve to life. So then it was a misdemeanor, and I was okay with that. But then it became no, a felony. And I'm just getting slaughtered here by the criminal justice system. So rather than do all that, I resolved it, but I resolved it where if I do wind up in front of a civil jury, nobody can say what's going on today. And I'm going to say my story with different lawyers, or maybe Mr. Rousey represents, I won't be involved. And the alleged victim's family, I'm not saying they're going to sue him, but if they do, they would have an even playing field without the benefit of this entire process going sideways for both sides. Those are my reasons to tell Mr. Stargell and the district attorney's office that a NOLA plea is essential. And that's why I believe a NOLA plea is much better than a first offender alpha.
And Judge, if I may.
You may.
Not talking over Mr. Steele, the misdemeanor that we had discussed was essentially statutory rape, which has the consensual component,
Right.
which doesn't necessarily need that protection of the NOLO in the event of a civil suit.
Okay. All right. Mr. Garland, was there something else?
Just briefly, Your Honor, that Claire wants to put this behind her today. There's no intent to file a civil suit here. We are not hung up on the NOLA issue. The issue we are on is the first offender.
Okay. Understood. Thank you. That's helpful. Mr. Steele, how, in your mind, does a NOLO plea that's not a first offender play out for Mr. Stargell?
It's NOLA plea, first of all, is great, right? I mean, everybody understands it's great under Georgia law.
So assume I don't understand and don't put adjectives on it because NOLO plea would not be great for someone. I just want to know what you think it operates to do. So if it were a NOLO plea, not great, not evil, just a NOLO plea, but not first offender, how does that affect Mr. Stargell's ability to go forth in life?
It would harm, we need this sealed, and that's the benefit of the First Offenders Act. It seals the records so this does not appear to the public in the future. So they're different animals.
And you don't think there'd be a way to seal things if it were a NOLO plea but not first offender?
I'm not aware of that.
I mean, you could always file a motion to seal and we'd see what happens. People seal things all the time. It just may not have that statutory basis.
Well, we like first offender. First of all, a NOLA plea is great, what I was saying, great in Georgia, but it's not recognized in other jurisdictions potentially. So in the state of Georgia, there's a statute. But if you go to federal court, they don't care if it's a NOLA. They're going to treat it as a conviction. They also don't care about the First Offenders Act, but we are trying to protect in this position this young man who has a future. So we would like, I see them as totally separate. They are not, it's not a Venn diagram. They are totally separate entities.
It's a Venn diagram. They just don't intersect.
Okay.
Got it. Okay. Mr. Stargell, you're in a tough situation. If what happened is the Ms. Hicks version, then you're a bad guy and you're going to have to carry that with you. If what happened is your version, then this has got to have been super frustrating to have this label attached to you and you're just struggling to reclaim your name. And if it's somewhere in between, speaking of Venn diagrams, and the two stories actually overlap some, and it isn't exactly what you're saying, it isn't exactly what I heard from Ms. McGillicuddy, it's still an unfortunate situation because Ms. Hicks is suffering and you've had this weighing on you. So it kind of goes all the way back to, I don't know what was going on August 4, where your dad had to come pick you up and bring you home because you'd been doing what you were doing. You're 19, you're not 21. So for the next couple of years, your evenings need to be not like whatever was going on August 4th. And you're nodding your head, but you're going to need to actually walk the walk going forward. So I find that there is a factual basis for your plea. This case would, in large part, end up being a he said, she said case. That's difficult for a jury. It's difficult for a prosecutor. It's difficult for a defense attorney. There's some scientific evidence that would not be great for you. There are some witnesses, if they said what Mr. Steele said they would say, and I'm not accepting his word, I'm just playing this out as I've heard it today, would make it a complicated case for the state. It wouldn't really add up. So I appreciate that Ms. Hicks and her family have reached a point where they just want to let it go and try to move forward, have you and your family out of their lives, not to forget, not to forgive, but to be able to move on. And I think a plea does that. And I think a jury could, if they heard the evidence that we've heard from both sides. In the end, he said, she said, credit what she said. And if they do that, then you're guilty. So I think there's a basis for me to accept the plea. I also find that your plea is knowing and voluntary. Voluntary means no one's forced you to enter this plea. You've had plenty of time and excellent counsel to advise you about whether to go forward. Do you agree that you are moving forward of your own free will?
Yes, Your Honor.
Knowing means you've understood it. I know I threw you a curveball and I apologize, but it just, the way Mr. Steele was laser focused on Nolo versus the best interest plea, I wanted to know if you had a particular perspective on it. But otherwise, I found that you were following along everything that was being said. Do you agree with that?
I do, Your Honor.
Okay. Then I will accept your plea. I will accept it as a Nolo plea. I also am going to sentence you as a first offender. I appreciate that Ms. Hicks and her family don't like that decision, and they're entitled to disagree with me. Rarely do decisions I make everyone in the room happy. I think that while what happened on that night has left Ms. Hicks with emotional scars that she will carry along for the rest of her life, the chance for you to not be forever labeled something that remains murky as we talk about the intersection of the stories is not inappropriate. It is appropriate in this situation. But you need to understand that first offender carries with it a risk. If we are back together again during the course of your probation for any violation of the law or any of these special conditions, then we got a very different story that we're talking about, because this is about a second chance. I don't really get to give Ms. Hicks a second chance, unfortunately, because this thing happened to her. You are getting a second chance, not that something didn't happen to you by having to go through this process, but you're dodging a forever label. And Ms. Hicks is going to wonder, what did you do to earn that? And part of it is, as far as I can tell, other than this night, you didn't do anything. You had no criminal history. Since that date, you haven't been in trouble, because if you had, Ms. McGillicuddy would have been telling me all about it. He got arrested at Georgia Military Academy. He had a minor in his room. He was drinking, anything like that. I would have heard all about that. It also wouldn't have been a no-low plea. It probably would have been a trial, and we would be heading in a different direction. You need to not misuse this opportunity that you have. It is easy at your age, playing sports, going to college, to mess up. And you've got tighter guardrails than your teammates and your classmates. That's all I can say. If we are together again while you're on your first offender probation because you screwed up, the outcome will be worse than if that's the only thing you did, because you were given this chance. Okay?
Yes, Your Honor.
I will sentence you to 5 years probation. The most important special condition of your probation is that you are to have no contact with Ms. Hicks or her family. That's no direct contact. Obviously, you don't reach out to them. No indirect contact. Other than your lawyers, no one you know purposefully reaches out to them. Not family members, not friends. Hey, Claire, just checking up on you. Or can't believe you said that about Mr. Stargell. If she or her family are getting contacted or seeing social media out there that relates to this and it flows back to you or people close to you, I'm going to see that as you violating that condition. That's a quick way to have your probation turn into forget about football, forget about college for now. You'll be taking a timeout for a while. So just keep away from them. It is not, however, a trap. If you are minding your own business and someone shows up, you need to document that and then move away from that situation. Mr. Steele described a couple scenarios that in his mind were Ms. Hicks coming into your space rather than you going into her space. I'm not crediting that. I wasn't there. But if something like that happens, you need to be real careful about it and not text back because you got a text saying, hey, you're not supposed to text me. Don't do that. You would let your lawyers know, I'm getting these texts that say, what about Claire or this or that? And you just inform your lawyers and you don't respond to them. Okay? You'll need to take an anger management course. You'll need to do that within the first 4 months of your probation. Probation can help you find one if your family doesn't help you find one. You will be subject to at least 4 random drug and alcohol screens a month for the first year of your probation. If those are all negative, then it can go down to 1 a month after that. But at least 4 a month, and probation may make it 6 a month or whatever they think is appropriate, but it will be at least 4 a month during your first year. And if those are good results, as in negative, then probation is authorized to ratchet that back. Ms. McGillicuddy asked that I impose a condition of no drinking. There's always a condition of probation to not break the law. It is not legal for you to drink until you are 21. So I don't need to say no drinking. If you get sanctioned at school for having consumed alcohol and probation learns of that, they can let me know and there's a violation. Obviously, if you get a ticket because you were driving under the influence, that's a bad one. You'll be subject to a Fourth Amendment waiver, which means in practicality, if probation has some reason to think, hey, we need to look at what's in your fridge or what's going on, they don't need a search warrant to do that. They just need to let you know, here we are. We're going to look around and make sure those aren't beers under your bed or whatever's going on at school. I appreciate what Mr. Garland shared about the special conditions that I could import from that separate set of conditions for people who are convicted or find themselves under sentence for a sex offense. I don't think the no residence with minors is appropriate because when you're home with your family, you've got a minor in that home and that's your sister. The no contact with minors is also a little complicated because you're in college and there could be a 17-year-old who is legally, properly enrolled at Georgia Military Academy, and that's a minor in some definitions. So we don't have a situation where you were a school teacher and it's your student who brought these allegations and we need to say, you know what, you're done teaching. You're not going to do that anymore. You are legally not a minor anymore. That brain in your head is still very much a minor's brain. It is not fully formed. I have an 18-year-old and he's a knucklehead, and it's going to be 4 or 5 years until I'm confident that he makes better decisions. I'm not confident you're going to make great decisions. I am confident you're going to think a little harder than some of your friends at school because of what's happened here. And that's a good thing because you need to be thinking harder with these 5 years of first offender probation following you around. I think that's it for the conditions. I thought about a curfew and even doing some initial electronic monitoring. But to me, the most important part is that you are staying away and out of Ms. Hicks's life and her family's life. And it doesn't sound like that's going to be an issue. If we hear otherwise, I obviously have the ability to modify probation, to do some things that lock down your ability to circulate. Obviously, you can go to class, you could go to practice, you could be at home. But for now, I think you being far, far away from Ms. Hicks is the best thing for her and a safe thing for you. And I'm going to leave it at that. But if I hear from the district attorney's office that for some reason you're having trouble with that, then we can revisit this. So I am sentencing you as a first offender. It is a nolo plea. I will look for sealing orders if someone wants to submit them in Word format to Ms. Nelson, my litigation manager, with Ms. McGillicuddy copied on that email, so she has a chance to look at them as well. Ms. McGillicuddy, you gave me the signed reaccusation. We'll get that filed. There is the no pros motion. Okay. All right. I will make sure that 25 SC 000407 is, I like the word dismissed. Null pros is the legal term, but the old indictment will be extinguished. Your plea is to the reaccusation that was assigned here. I think the only thing left is to give you probation reporting instructions, which Ms. Simpson will help with. Oh, there is one more thing. Ms. Simpson reported Mr. Steele and Ms. McGillicuddy, after speaking to her assistant chief, that if I put language in the final disposition that Mr. Stargell is not required to register as a sex offender, that will control what probation does, given this offense of conviction. Obviously, if it was a child molestation, I could write that 100 times and he'd have to register. But that is not what the offense is. And so I will put that language in there. I will also put language in there that the defendant does not have any sex offender special conditions of probation. That will ensure that that extra list ends up not being brought in by a probation officer who wasn't part of this conversation and didn't hear everything, to include Mr. Garland's well-placed suggestions that several of them ought to be incorporated, which I've heard and carefully considered, not ignored. So I'll make sure that language gets into the final disposition. Having said that, Ms. McGillicuddy, anything else from the state?
I don't believe so, Judge.
Okay. Mr. Steele, on behalf of Mr. Stargell.
Can I just verify, maybe the district attorney, it's accusation number? I just want to know for our motion to withdraw the plea, if there is, and I understand everybody's intention, it's not to have it happen, but if Mr. Stargell is on sexual registration, 26 SC 023443.
002043.
Thank you.
You're welcome.
Other than that, Your Honor, I don't have anything else.
Ms. Hicks, I appreciate you being here. I know this is a difficult time for you, and you may have many times hoped for a different outcome for Mr. Stargell. I don't want you to leave here thinking that no one listened or no one cared. That is not what this is about. It's about a complicated situation where I think your family and your lawyer gave you some good advice that agreeing to let this work out so that you don't have to come into court and talk about this in front of a bunch of strangers on a live stream trial probably brings you more healing than an apology or anything else could have brought you. I want you to know that I wish you the best as you move forward. You need to let your family know if there's any kind of outreach you're getting that you think is associated with this, because no one other than the district attorney's office, I don't know why they would, but if they do, would be reaching out to you to be checking on you.
Okay, guys, there you have it. Can you even believe this case? I'm thinking, what is going on in Fulton County, Georgia? a mom and dad can let their young daughter go spend the night having a sleepover with two of her besties, and within hours of letting her leave the house, they are at Children's Hospital getting a rape kit test done on their daughter, which of course the defense attorney says, sure, Andrew's DNA was found, but that's because she was in his bed. But he is not pleading guilty to rape. He is innocent of that. But who was standing up for Claire? Did you hear anyone really pleading her case or standing up to the defense attorney and Andrew in any way? I sure didn't. I can understand that the parents and, of course, Claire doesn't want to have to go and her take the stand and be attacked, which she would. But the sad part is it probably wouldn't only be the defense attorney saying, what were you wearing? I would almost expect this district attorney and even the judge to join him in accusing her of whatever needed to be accused in order to get Andrew totally free from any consequences. It's an unbelievable case. What do you guys think? What stood out to you in this case? Did you see how the DA and the judge were falling all over themselves to make sure Andrew Sargel came out smelling like a rose? Such a travesty of justice. The defense said he thanked the judge and the DNA and said, I've litigated many cases. Basically saying, I've never had anybody basically pleading my case for me, which is what the DA and the judge was doing. It was like he couldn't even believe it himself. So the defense barely had to say anything. The DA and the judge pled his side for him. Is that how you guys saw it too? Or was it just me? So the defense said, Andrew's family doesn't wish any harm on Claire or her family, but Andrew has been through a lot over this and has lost a lot of opportunities. Okay? And Andrew's family just wishes that no other family has to go through what Andrew has been through. Oh my goodness. Unbelievable. It's like that's the only thing I can say. That's the only thing that comes to mind. This whole thing is unbelievable. The defense said Andrew's not pleading guilty. He's pleading to only child sexual battery. The parents of Claire wanted a few things. They wanted him to have some house arrest, no contact with Claire or the rest of her family. They didn't want him to get first offender status, which they knew he was going to get basically a slap on the wrist. They wanted him to have a curfew. Is that too much to ask? They wanted drug and alcohol screening. Okay, but the judge's sentence for Andrew Sargel, which this is a felony offense, everybody agreed. He gets 5 years probation, but he can petition the court for early release of the probation. Andrew will get no jail time, no prison time. He has to take an anger management course. Drug and alcohol screenings just at the early stages of his probation, not throughout. No electronic monitoring for Andrew. Nope, you get to be on that phone, laptop, computer, looking at anything. Who knows? He should be monitored to make sure he's not looking at child porn, at least during his probation. The judge said Andrew isn't legally a minor, but his brain is still not fully developed yet. He has no requirement to register as a sex offender. Don't you think other parents need to know who is living among them? After probation, this is really crazy. After probation, if he successfully finishes probation, this whole case goes away. There will be no record of it. Nobody can ever look up his name and see that he had ever committed a child sexual abuse in any way. And this is one of the worst parts, when the judge is talking to young Clair and saying, "You may have wished that I had given him a harder sentence today, Clair. But you basically have dodged a bullet. You don't have to come up and talk to strangers about things you don't want to talk about. So, yeah, you just think of yourself as being lucky, Clair. You're lucky you didn't have to tell anybody what he did. Everybody else should have been standing up for her." Again, I just wish this case would have been brought before Judge Stephanie Boyd out of Bexar County, Texas. Oh my goodness. Andrew would not see the light of day for a very long time, and he would have time. It would be like the government would be sending Andrew to his room for a few years to think about what he did, about the choices that he made. But anyway, that's my take. What's yours? What do you think? Drop your comments below. I'll read every single one of them, and we'll talk about it again later. But until then, until we meet again for our next court case, this case is closed and court is adjourned.